An Ottawa Justice of the Peace is facing discipline over a newspaper article she wrote calling out problems in the bail system. Julie Lauzon wrote in a 2016 opinion piece in the National Post that the law goes out the window, and cynicism and bullying kick in at bail hearings at the Ottawa courthouse. Justice of the Peace Julie Lauzon, who presides at an Ottawa courthouse, is accused of publicly denigrating the integrity, honesty and professional reputations of Crown attorneys. Richard Loughton's Toronto Star file photo between forced rushed video appearances, a lack of respect for the JP bench and the absence of the rule of law in this court. I can no longer call it a court of law. It is a disgrace, she wrote. I am there to administer justice. It is not my job as a JP to sign off unreleased documents that are unlawful. Lauzon also wrote of a Crown attorney turning his back on her in court and telling defense lawyers that all deals were off the table as long as I was presiding, while she said she had another prosecutor scream at her and basically throw a temper tantrum after I questioned certain conditions. The piece, which had been praised at the time by criminal defense lawyers for shining a light on systemic failures in Ontario's bail system, is now the focus of a discipline hearing against Lauzon at the Justices of the Peace Review Council, the independent body tasked with investigating and disciplining JPs. Article continued below. Read more. Ontario judge blasts bail hearing, tainted by legal error. Opinion, time to overhaul Canada's unjust bail system. Toronto Justice of the Peace accused of bullying and mocking. Defendant. 3 complaints form part of the case against Lauzon. The effect of Her Worship's comments was to publicly denigrate the integrity, honesty and professional reputations of Crown Counsel, says a notice of hearing posted on the Council's website, outlining the allegations of judicial misconduct against Lauzon. The allegations have not been proven. Dates for a discipline hearing will be set in August. Lauzon's lawyer, Dominic Lamb, declined to comment to the Star. Article continued below. Her Worship failed to uphold the integrity, impartiality and independence of Her Worship's office, and of the judiciary, says the notice of hearing. In addition, in making such one-sided negative comments publicly against the Crown, Her Worship's comments gave rise to a reasonable apprehension of bias against the Crown, thereby bringing the administration of justice into disrepute. Justices of the Peace, who earn about $132,000 a year, are appointed by the provincial government. Clad in black robes and green sashes, their duties include signing off on search warrants and presiding over bail hearings and trials in Provincial Offences Court, which details with non-criminal charges. Lauzon was appointed in 2011. She had previously worked as a lawyer at the Tax Court of Canada and as an air navigator for the Canadian Forces, according to a news release announcing her appointment. The JP's opinion article was published at a time when the province's system was facing strong criticism, particularly from defense lawyers, for leading to the over-incarceration of individuals who are legally innocent. The defense bar had called out stringent conditions for release on bail and the over-reliance on sureties, persons who promise to ensure that an accused person complies with the bail conditions, and who puts up money that they can lose if they fail in their surety duties. This is a ridiculous situation. Nothing Justice Lauzon says in her article is untrue, said Ottawa criminal defense lawyer Michael Spratt, who has appeared at bail hearings in front of Lauzon and described her as fair and understanding, and most importantly diligent and impartial. What she describes seeing in bail court: the over-reliance on sureties, the over-reliance on conditions, the over-reliance on detention, the lengthiness of procedures and the disrespect that can be seen in bail court sometimes. These are all things that have widely been acknowledged, Spratt said. He pointed out that many of these issues were highlighted by Attorney General Yasser Naqvi last year when he announced the province's new bail directive for Crown attorneys. The directive reminds prosecutors that the default position at a bail hearing must be the unconditional release of the accused person ahead of their trial, and that they must consider that step before rejecting it and moving up to a more stringent form of release. It's tragic to see that JP Lauzon is being disciplined for her courageous efforts to shine a light on the daily injustices she observed with our bail system, said lawyer Daniel Brown, a Toronto director of the Criminal Lawyers Association. Judicial officers must be free to speak about the problems within our court system in order to effect change. Her piece sparked debate within the justice community and spurred action from our elected officials. JP Lauzon should be commended, not disciplined. Lauzon also faces discipline for comments made during 3 bail hearings, some of which could be perceived as reflecting a reasonable apprehension of bias against the Crown, according to the JP Review Council's notice of hearing. Jacques Gallant is a Toronto-based reporter covering legal affairs. Follow him on Twitter, @JacquesGallant.